All right, the jury's absent. We're still in session. I do note that Dr. Calloway is present, and Mark Sokol, I believe, who appeared on her behalf at a prior trial, is also here. And I had notified the prosecutor, I think last evening, to, at least as a matter of courtesy, to let her know that she'd be called today, and that if her attorney wanted to express any concerns at this trial, as he had expressed previously, I would be glad to hear him and her. Do you intend to call Dr. Galloway for as the state's witness in this case?
Yes.
Okay. Would she be called this afternoon?
Yes.
Okay. Do you intend to attend to her as an expert witness? I believe she was called as a fact witness in the last trial, and we all had an understanding that she was being attended to the court as a fact witness. That, you know, people who have some expertise are sometimes called as fact witnesses and are sometimes called as experts, but there's a significant difference between the two. So.
At this point, we don't intend on calling her as an expert witness, despite the fact that she has some training experience as a psychologist.
Okay. I believe I received allowed the report of this witness in a limited way in the matter of Grant Hayes. Specifically, I allowed her report to be considered as it had any relevance or bearing upon the state of mind of the defendant, Grant Hayes, and the state of mind of Laura Ackerson at the time of Ms. Ackerson's death. Not necessarily to be considered by the jury for the truth of anything asserted therein, or as to whether or not there was a professional basis for the opinions given, or whether or not the opinions were professionally valid, but only to the extent that the victim and Grant Hayes knew what the report said, and they may have gained impressions from that report that caused them to take certain actions, in part based upon that information, and perhaps some concern of what a district court judge might do with regard to the custody issue. We're not here today, nor were we here in that trial, to litigate who would have gotten custody of the children, whether or not the evaluation was favorable to one side or the other, or how it was conducted, or anything of that nature, or what the district court necessarily would have done. I don't recall Dr. Galloway being asked anything about her, what she would have testified to at the hearing in the district court either. I think she was asked only what she did, and basically what she reported, and what was part of her report. Do you intend to ask me to qualify her as an expert?
Your Honor.
And I won't do that. I will not qualify her. You would have to qualify her based upon how she answered your questions. Okay? So, all right. But we'd have to do that out of the presence of the jury, so I'm just kind of curious now as to whether or not you anticipate doing that.
We do not intend to ask that she be allowed to testify as an expert witness. We do, however, intend to elicit information from her about her experience and education in the psychological field, information that she has received in her experience and training essentially, we intend to ask her a lot of questions about what she might or might not know, having learned those things in her experience and her training, but we don't intend to ask her to express any expert opinions. It's more in the sense of information that she would know through her experience, but we're not going to go that extra.
In general?
In fairly general, but we don't intend to take that extra step of asking for any opinion.
All right. I don't know what that means, but I don't have a clue what that means. But I mean, I assume you have a valid basis to ask her if she was appointed by the court and what her qualifications were for the court appointment, what her background experience were to qualify her to make a recommendation to the court, and her knowledge and based on that background experience and concerning general concepts of psychological testing and evaluation and that sort of thing. Is that what you're saying?
I think that we're on the same page. I think that we intend to ask her what may turn out to be a lot of questions about things that she knows in her psychological training.
Okay.
We simply don't intend to ask her questions that would require that she be qualified as an expert.
All right. Well, I mean, I'm trying to understand what you're saying. You've used the term sociopath, psychopath. Do you intend to ask her if she understands what the definition of a sociopath is, what the definition of a psychopath would be? Is that what you're going to tell me?
That's where we're headed.
Okay, as part of her background, training, and experience.
Exactly. That's where we're headed.
Are you going to ask her an opinion as to whether or not anybody involved in this case fits that criteria?
No, we are not.
All right. Okay. What?
Your Honor, I think we'd like to be heard before that happens, because essentially what this is doing is just putting in front of the jury, asking all these questions about what's a psychopath, and it's a thinly veiled attempt to correlate defendant Grant Hayes, the co-defendant Grant Hayes, meeting his definition. If the questions are just general about what constitutes a psychopath, what constitutes a sociopath, it's not relevant to this matter. There's no relevance whatsoever. If I were to ask Dr. Calloway and her training experience about other psychological diagnoses, I would be precluded from doing so because they're not relevant. So that would be our objection to that. I don't purport to know exactly how it's going to go, and maybe I should just object when it happens.
All right. Okay. Mr. Sokol, do you want to say anything?
Yes, Your Honor, because I think Dr. Calloway is troubled by the potential that, although she's not going to be asked to be qualified as an expert, in giving testimony about the definition of diagnoses or conditions, she is in fact being asked to testify as an expert, knowing more than we do as lay people about these things. And so she's concerned that that area of questioning goes beyond what she feels comfortable under her guidelines and rules, allowing to do, since she is not been subpoenaed as an expert, hasn't been retained by anybody as an expert, and yet it sounds as if some of the questioning is going to be beyond the area of a layperson. What's a psychopath and what are the characteristics? And
Well, she was appointed by the district court of Lenore County as qualified to make a psychological evaluation based upon her background experience, certification, to make a recommendation to the court with regard to the custody of two children, which required her to rely upon her training and experience as a psychologist. Certainly she could be asked in making any kind of an evaluation with regard to a child or anything else in child custody, how you go about doing that, and whether or not you look at the parents and any mental health issues that they may have, and how that affects your analysis and your evaluation. in general, as opposed to specifically in this case, and including if she refers to DSM, any kind of a psychiatric evaluation or anything else. I think that's a valid inquiry by the parties from both sides. You know, if you're an MD at an emergency room looking at a gunshot wound, you may be called as a fact witness to say, I opened somebody up and they suffered a gunshot wound. And we all know what that looks like, pretty much. But asking opinions as to how it was inflicted and that sort of thing, all of a sudden you get beyond that. So I'm not sure exactly what your client's concerned about.
Her guidelines permit her to testify as an expert within the realm of the assignment she was given, subject to the issues and her inferences and so on.
Okay, well, I don't.
And all she's saying is that she feels as if her guidelines say she cannot be testifying about inferences she made or opinions she has about things outside of what she was retained to do.
Okay, well, I respect that. I respect her concern about what she is ethically permitted to do in this courtroom based on her testimony as a psychologist. I may determine that the interests of justice require that she exceed what would normally be expected of her under her own guidelines. Right, and I wanted, I was trying to find out how far beyond those guidelines that anyone's going to ask her to go, and I can't tell right now, but I am going. I do believe that this is a legitimate inquiry from both sides, in good faith made. I will not expect her to answer any question that she does not feel qualified to answer. If she's asked some question with regard to some concept that she is not familiar with, or an opinion with regard to the application of that professional concept to certain facts, and she's not comfortable answering that, or not, she doesn't feel like she's qualified to answer that, or she has no opinion about that, I hope she will freely indicate that she does not have such an opinion. But I will compel her to answer any question that comes up during this trial that's objected to, and I decide that it's appropriate for the jury to hear her answer to the question, and I'll just either sustain the objection or overrule the objection, and then she can respond accordingly. And I appreciate her bringing that to my attention again, and I understand her professional concern. Anything else? All right.
Just one thing, Your Honor. We've all.
Right, right. There's one. There was a reference in the in Dr. Calloway's report in which the term, I think, eradicate was obliterate. Okay, I'm sorry, obliterate was used. Because that term is maybe taken in a number of different ways. And I'm not sure that it has a specific meaning as it's generally understood and used. The jury could reach different conclusions about what was intended by that term in this report, and therefore I'm going to instruct her not to use that term or make reference to that term unless the court specifically, in the context of a question, believes it would be appropriate, and then if I do, I will instruct her that she can make reference to the term. But unless I do, I'm not going to allow her to make reference to that term from this report as it relates to this defendant. I did not make that ruling in the previous trial But as with regard to this particular defendant, I believe that the jury may get the wrong impression if that term is used. All right. Anything else?
No, Your Honor.
Okay. Thank you. Sheriff, we're going to be in recess till 2:30. Thank you.